Hello neighbor, I'm Robert Burns, and it is such a delight to come and to be with you again to bring you up to speed on the ongoing litigation entailing Henderson Auctions and a gentleman named Blake Everett. We last updated you on that lawsuit back in January of this year, a couple of months ago, but I'll take just a moment to bring you up to speed from the very beginning. We're going to have the webpage that shows all of these videos, and I would welcome you to go back and look at the detail of what is entailed in this litigation. But we believe by doing this, we are providing auctioneers all over the state of Louisiana and in other states for that matter, because we have quite a few auctioneers from other states on our distribution list. We believe we are providing the highest quality of continuing education that is available in the market today. We're not talking about going in and digging through some textbook. We're talking about real live examples of situations that get rather sticky in the auction industry. All right, let's talk about what's going on with this Henderson Auctions litigation. We are talking about the sale of the Crown Casino some couple of years ago. That was a situation in which Marvin Henderson and a gentleman named Blake Everett went in together. They acquired the Crown Casino. They also acquired numerous other pieces of property and whatnot that the Henderson Auctions lawsuit says they were to be sold off, and they would share the gains and the losses and whatnot. But in this particular situation, it was alleged that the boat was acquired for $600,000. There were approximately $300,000 in improvements and storage costs, things of this nature, so that they had $900,000 into the Crown Casino. Now, there was an attempt to auction off that Crown Casino. It did not go well, and therein lies a lesson of continuing education. You can get a very specialized product like that, and even though the cost to build it may be 10 or 12 times the amount you pay for it, if you don't have the specific buyer that can meet the specific need, particularly say one may need a gaming license in order to be able to make use of it, you may find a very limited market. I'm not going to suggest that's what happened in this situation. All I know is the attempted auction of the casino, the Crown Casino, didn't go well. And so consequently they had to go into negotiated sale mode. They promoted the auction some years back, 2014 give or take. I can't remember the exact year of when all this took place, but I believe it was 2014. And this Crown Casino auction didn't go well, and so they had to go into negotiated sale mode. And ultimately there was a buyer found, and the transaction was to take place such that there would be $350,000 in cash plus title to a property that is called the Ivy House in Kosciuszko, Mississippi. And I believe I've got it all right this time. So $900,000 is now in the casino. $350,000 cash is what's obtained. $550,000 being what is left needed. And there is title to this Ivy House in Kosciuszko, Mississippi. Now, the original lawsuit that was filed by Henderson Auctions back in, I believe, October of 2014, that lawsuit stated that there was an attempt to place this Ivy House into an LLC controlled exclusively by Blake Everett, and that he was to auction it. He made an attempt to auction it, and there was not going to be any sharing of the proceeds. And so in the Henderson Auctions lawsuit, they alleged fraud, misrepresentation, things of that nature. And I'm not going to go into the whole thing because you can go back and watch the very first video, and it's gone into in great detail. They dispute the fact that Mr. Everett was entitled to any time compensation for the time that he spent in preparing this thing for auction and for sale and things of that nature. And we pointed out from that whole episode that there's several lessons can be learned. First of all, whenever you're dealing with merchandise that you actually own, that can become problematic. Also, when you're in joint ownership with someone else, it is absolutely critical and paramount that you get a firm understanding in writing of who's going to get what, and that is, and it's even required in the state of Louisiana for any auction of goods that's over $500. For the sale of goods for over $500. Everything ought to be in writing. And certainly when you're dealing with real estate, if you're going to try to assert to a court that you have ownership interest in real estate, you better have something in writing. And therein lies the problem. Henderson Auctions, they filed this lawsuit in Livingston Parish alleging the fraud, the misrepresentation, things of that nature. But they also filed, when they obtained knowledge that there was going to be an attempt to auction this Ivy house in Caviasco, Mississippi, they filed, first of all, a temporary restraining order to try to block the sale, but they also filed a lis pendens. And we talked before about what a lis pendens is. A lis pendens basically says that, hey, look, everything needs to grind to a halt here. There can't be a sale of this because we either have litigation or we are anticipating imminently filing litigation. And of course, there is Livingston Parish litigation that was filed, and that was the basis for the lis pendens in Mississippi. Now, that dragged on for a year and a half. There was a year and a half that the parties met. They had hearings in court, whatnot. The judge said, look, you're going to have to produce something in writing that shows where there is an evidence of you having ownership here. That was not able to be done by Henderson's Auctions, and so as we told you in the January update about things that were going on in Mississippi, the judge tossed the lis pendens. Okay. And at that point, where we left off in January, we told you that Henderson Auctions had just filed in Livingston Parish to have a curator appointed to represent Mr. Blake Everett, because they said he had not been served. And never mind that all this stuff had gone on in Mississippi, the fact of the matter was that they were alleging that there had been no service of the Louisiana lawsuit. And so they were looking to appoint a curator, typically a curator who's going to basically stand in the shoes of the absentee litigant. That's usually done for debtor-creditor type deal where you can't find the debtor anymore, and so a curator gets appointed. It's usually a process by which a creditor goes through to more formalized foreclosure. But be that as it may, that's what was done in this case. It may have been somewhat bizarre, but that is what was done. There was an attempt to appoint a curator, and in fact a curator did get appointed. A gentleman named David Guidry, who happens to be the city prosecutor in Denham Springs. And I told you about how once all of this stuff gets involved in litigation, the one set of folks that are guaranteed to make out are the attorneys. And a case in point on that is Mr. Guidry. All right. Now, he did nothing but become appointed curator, picked up the phone, found out that, hey, these guys they've got counsel to represent them, so I'm backing away from this, and he submitted an order to be compensated to the tune of $350. We're going to give you a link for that order. And I say that just to say this, there's token involvement there, very minimal involvement, and yet now $350 is going to be assessed against somebody whenever this whole thing is resolved. Now, as I said, Mr. Guidry made it apparent that Blake did have Louisiana counsel. It's a firm from Covington, Louisiana. And they said, oh, no, we'll take over from here. And so the first thing they did is to transfer the matter out of Livingston Parish Court, 21st JDC, and into federal court in Baton Rouge, Louisiana. That's a very favorable development from our standpoint because it's much easier to monitor federal court. It's much closer to my home. The filings are easier to obtain and things of that nature. So we will keep you up to speed on everything that goes on with that federal litigation. And let me bring you up to speed on where we are right now with regard to that federal litigation. And let me just say this, that's another lesson to be learned here in continuing education. When you have diversity of citizenship, Mr. Everett, both Blake and Sam, both reside in Mississippi. Obviously, Henderson Auctions is based in Louisiana, thereby permitting the transfer, making federal court an appropriate venue because you have diversity of citizenship. So you might say the attempted home cooking, if you will, and I'm going to use that phrase because Mr. Henderson has never failed to brag about Livingston Parish Courthouse and how even the Louisiana Department of Revenue does not want to try him in Livingston Parish. And we gave you the little clip from January of him bragging of that, the Louisiana Department of Revenue, they didn't want to take him on in Livingston Parish. And obviously Blake's attorney said, yeah, that dog ain't gonna hunt. We're not gonna do this in Livingston Parish. We're going into Baton Rouge federal court. All right. We're going to give you links to all of the filings that have been made in federal court, but I'm going to quickly get you up to speed on what's going on. First of all, there's been a motion to dismiss Sam Everett as a defendant. Sam apparently had virtually no involvement in any of this. He doesn't reside here. Has no contractual relationship whatsoever. At least it's all in a sworn affidavit that we'll give you the link for. And so the first thing that's been done is a motion to dismiss Sam Everett, that's Blake's father, as a defendant. Now, Mr. Everett's attorney made a motion for oral arguments to be made with regard to that matter. That motion was denied. We'll give you that order. And they said that the magistrate judge, Shelley Dick is the judge to whom this has been assigned, but they have said that the magistrate judge will inform the parties if in fact there is a need for oral arguments to dismiss Sam Everett from the lawsuit. Basically, the other aspects that are going on thus far through today on the federal filings entail the answer to the litigation that was filed in Livingston Parish. Bear in mind, everything is now in federal court. And I'm just going to quickly tell you that the basic defenses are that we deny the vast majority of the allegations that are made in the petition. When I say we, that's for the Everett now. They're answering the lawsuit and saying, hey, we deny the vast majority of the pleading components in the lawsuit for lack of a basis to form a belief thereof. They also assert that even if there may be some validity, some of that the Hendersons are coming to court with dirty hands. And we will elaborate upon that shortly, but there's a statement that they're not coming into court with clean hands, and there's an old doctrine that, hey, when you come into court with dirty hands, don't expect for the court to reward you for such. And then, of course, they also would assert that even if you do find that they are owed money, we certainly are entitled to a right of offset because we, too, claim that we are owed money. And in fact, if you go to the heart of the matter, and even more prevalently, because the title of the email was that Henderson Auctions is sued in federal court. And so not only did they answer, but they also filed a countersuit. And so Blake Everett is now suing Henderson Auctions in federal court. And let's talk, since the first episode that we did covered mainly everything from Henderson Auctions standpoint, let's now focus in on what Mr. Everett alleges transpired during this whole ordeal, because it's quite interesting to compare and contrast the two. Now, Blake, through his attorney, says that he and Marvin had an agreement to that Blake would scout out equipment and whatnot. And if Henderson Auctions was interested, they would purchase it and then would subsequently sell it, typically through auction, and that there would be a 50-50 split of either any rental income or any sales profit. But importantly, Blake says that he was not to share in the losses. Henderson claims that he was, that Blake Everett was to share in the losses. Blake mainly asserts that he was more on a commission basis and that he would be entitled to rent or 50% of any profit, but not an offset on the losses. There is a spreadsheet supplied, and we're going to give you a direct link to the spreadsheet in which Mr. Everett itemizes out all of the different transactions that they were involved in, including the Crown Casino, and he totals everything up, and his assertion is that Henderson Auctions owes him just a tad over $600,000, and we're giving you the link for that spreadsheet, which has been filed into federal court. They also assert that Henderson Auctions owned and utilized some of the merchandise in question here, particularly some mulchers and an excavator. That's what a reference to about dirty hands coming into court. They also assert that some B&B fire equipment that was part of one of the transactions, that got sold, and that Everett was never provided with any kind of accounting whatsoever for that particular itemization. And so there again, going back to, an allegation of dirty hands, they're saying, well, here, all this stuff was sold and we don't know what you got for it or anything. So we may well be entitled to some funds on that for sure. And then the suit goes on to state that, look, the boat storage costs were escalating. And so it is asserted that Marvin indicated that, or JAH indicated that, look, we got to get this boat sold. And so the assertion is made that All right, with this $450,000 coming from a buyer. Now, we did tell you in the last episode that it turned out that the buyer, at least who the boat was conveyed to, was an entity controlled by Blake Everett. But at any rate, that entity wired $340,000 to JAH Enterprises. Now, where did the $340,000 come from? Well, if you'll remember, we talked about a $350,000 sales price. There was a $10,000 offset on some previous debt that was owed, and so that was your $340,000. Now, here's what's important. What's going to happen with this Ivy House going forward? It was asserted that, okay, when we sell this Ivy House, there was to be a $50,000 split. Blake was to get his $50,000 commission. Marvin would get $50,000, but subsequently that was modified, and it was said that, hey, there would be a 50-50 split on this thing without any kind of withholding on it. And Blake also asserts through his attorney in there that not only had he already advanced Marvin $30,000, but he also advanced him the $50,000 that Marvin would have attained upon the ultimate sale of the Crown Casino, but then another $50,000 beyond that. And so those are the basic elements that are outlined in the countersuit, which basically is saying, hey, you owe us money, all right? It's also asserted in there that Marvin Henderson failed to tell his daughter, Janet Cagley, and that she then demanded that the Ivy House be transferred to J3 Investments. Now, that's an entity that I believe is in both Janet and Jeff's name, Jeff being Jeff Henderson, Marvin's son, who is the board member on the Auctioneers Licensing Board. The attorney for Mr. Everett referred to J3 Investments as, and I quote, JAH Enterprises, quote, alter ego, unquote. But at any rate, Blake said, oh, no, that ain't happening, okay? I ain't transferring this over to JAH, and now we have a dispute that the court is somehow going to have to try to settle out. And I've presented to you in the first episode the Henderson's representations. Now we have Mr. Everett's representations. But I think one could agree that, hey, this really drives home the point and the need for definitive written agreements to be in place. You know, all of this wheeling and dealing is great, but, you know, you come into court, I mean, the one set of folks that are going to make a lot of money off of this is, guess who? The attorneys, all right? All of which can be avoided if on the front end you get very definitive written agreements about who's getting what so that there can be no confusion. If the allegations in Blake's lawsuit are correct that Henderson didn't tell Cagley of this whole arrangement, you know, I mean, it just begs for the left hand maybe not knowing what the right hand is doing. And you need to have a unified front and have all your ducks in a row and everything reduced to writing, and these types of disputes can be avoided because the one thing that is guaranteed from all of this is that a significant portion of the pie, remember that I referred to in the pie in the very first video that we talked about, there's attorneys involved now, so that pie is going to get cut in significant portion, and those folk are going to get their money, and not to say they don't deserve it. I mean, somebody's got to sort this mess out, and it'll be interesting to see just how the court sorts it out, because you know, the court's going to probably want to rely on something in writing, okay? And Jeff Henderson, who's, I don't know if he's even mentioned throughout any of these pleadings, yet he would be the one, presumably, that would have the legal authority to bind the company. But everything seems to be being done by Marvin. You know, it's just going to be an interesting situation to see what the courts are going to be able to make of all this, because to the degree there is writing, it's inadequate to definitively say this is what was agreed to here. So quite a few things have been learned. In summary, get a definitive written agreement, especially when you're talking about dollar amounts of this magnitude. When you're talking about having an ownership interest in real estate, get it in writing. It's the only way it's going to be acknowledged by the court. That was ascertained up in Mississippi. No evidence to produce you had an ownership interest in the Ivy House, thus the tossing of the lis pendens. Diversity of citizenship. You may not be able to have this thing tried in the courtroom you'd like to have it tried in, okay? When you're dealing with out-of-state litigants, this thing can wind up in federal court. Obviously, it's a lawyer's job to put litigation into a forum most advantageous for his or her client. Clearly, that's what's being done here by Mr. Everett's attorney. So those are just a few of the things. We talked about the lis pendens. We talked about the need for getting things in writing. And as most of you would know, there's presently an effort to reinstate continuing education in the state of Louisiana. Ironically, that's being spearheaded by Jeff Henderson. He is to meet with Sherman Mack, the sponsor of the bill. I just want to relay to everyone that irrespective of whether continuing education is reinstated or not in Louisiana, you have our word that we will continue to bring you these types of real-life instances to demonstrate how to go about getting the ducks in a row for staying out of legal problems in the auction industry. So once again, this is Robert Burns. It is such a thrill to bring you up to speed. We will continue to bring you up to speed as developments unfold in this federal litigation involving now its cross suits of JAH versus Everett and Everett versus JAH or Henderson auctions. Once again, thank you so much. We look forward to bringing you more details as they unfold.